Good evening and welcome to the conference on arbitration and enforcement at the India Law Forum and LITFest, organized under the aegis of the 82nd SKOCH Summit by SKOCH Group. The SKOCH India Law Forum and LITFest is an independent platform for changemakers committed to bringing about a transformative change to the nation through law and legal reform. ILF seeks to bring together India's leading legal luminaries at the intersection of law and life. In 2014, India was ranked 142 out of 190 countries in the World Bank's Ease of Doing Business rankings, and since then it has catapulted 79 positions to 63 in the 2020 rankings. The World Bank credited this mercurial rise to India's major policy reforms, including the creation of the Insolvency and Bankruptcy Code 2016 and the removal of red tapeism in starting the obtaining of permits. Despite this improvement, India continues to struggle with the parameter of enforcing contracts, where its rank remains stagnant at 163 out of 190. Our distinguished panel of experts discusses the progressive developments and regulatory challenges therefrom. We're honored to have Justice R.V. Ravindran, former judge of the Supreme Court of India. After 25 years of practice as an advocate, Justice Ravindran was appointed as a judge of the High Court of Karnataka in February 2003, elevated as Chief Justice of the High Court of Madhya Pradesh in July 2004, and as a judge of the Supreme Court of India in September 2005. During his tenure as a judge, he also served as the chairperson of the High Legal Services Committee, Karnataka, the chairperson of the Karnataka State Legal Services Authority, the chairperson of the Supreme Court Legal Services Committee, the chairperson of the Supreme Court Mediation and Conciliation Project Committee, and after retirement, he's been engaged in arbitration and mediation and has also served as chairperson of the New Broadcasting Standards Authority. Justice Ravindran is a member of the Board of Trustees of the International Arbitration and Mediation Center, Hyderabad, and has authored an excellent book that I was just reading titled Anomalies in Law and Justice, Writings Related to Law and Justice, the foreword for which has been written by Justice M.N. Venkatachalaya. Mr. U.K. Sinha, Distinguished Fellow, SKOCH Development Foundation, and former Chairman, the Securities and Exchange Board of India. Not only is Mr. U.K. Sinha the former Chairman of SEBI, he has also received the SKOCH Challenger Golden Jubilee Award for his contribution to market reforms during his tenure as Chairman SEBI. He was also the Chairman and Managing Director of the Unit Trust of India Asset Management Company. He has also chaired the RBI Expert Committee on Micro, Small and Medium Enterprises. Formerly with the Indian Administrative Service, he has held several responsible government positions in India, including Joint Secretary Banking, Joint Secretary Capital Markets in the Ministry of Finance. He has recently authored a widely acclaimed book, Going Public, which was featured at the SKOCH Public Policy Forum and LITFest, and has served as chairman of the Working Group on Foreign Investment in India, and has been a member of committees set up by the government, including those on liquidity management, foreign institutional investors, the corporate bond market, and investor protection. Mr. Aman Lekhi, Senior Advocate, Supreme Court of India, and the former Additional Solicitor General of India in the Apex Court, has been practicing for several decades. In addition to his appearances and role in the Indian coal allocation scam case, the 2G spectrum scam case, and the Commonwealth Games scam case, He has argued under the Right to Information Act 2005 against the UPSC with regard to Civil Services Preliminary Examination 2006, subsequent to which the UPSC had to change the pattern of the examination itself. As a lawyer, he has argued several matters relating to the telecom sector involving the TRAI, wherein also he has achieved notable success. Mr. Lekhi practices in the Supreme Court and the High Court of Delhi. He appears regularly on various other high courts and different tribunals. He is actively involved in several arbitrations. Ms. Nichi Sachdeva, Secretary General and Registrar, the MCIA. Prior to joining MCIA, Ms. Sachdeva procured extensive experience in the field of international commercial arbitration, both as a private practitioner and as an administrator. Having worked with some of India's leading law firms, she also worked with the International Arbitration Department of Freshfields in their Paris office and served as a judicial clerk for Justice Geeta Mittal and Justice Muralidhar of the Delhi High Court. Ms. Sachdeva has also worked with the LCIA India as its first deputy registrar and holds academic appointments with the KIIT Law School, Odisha, and HNLU Raipur, in addition to NLU Delhi. Mr. Rajiv Goswami is head legal Vedanta Limited. Mr. Rajiv Goswami is a seasoned legal professional with a rich and varied experience of 20 plus years in the disciplines of strategic business advisory, corporate and commercial laws. He is currently heading legal and land at Balco and has previously worked with various financial sector and technology companies. He has also been an entrepreneur and incorporated Intelextra, a pioneer organization in the legal process outsourcing sector. He holds academic appointments in various institutes, including the ICSI and various IIMs. Mr. Tejas Karya is partner and head arbitration, Shardul Amarchand Mangaldas and Company. He is advised on the draft amendments to the Indian Arbitration and Conciliation Act 1996 and Commercial Courts Act 2015. He has also been a part of the high-powered committee for the institutionalization of arbitration in India. He is a member of the Singapore International Arbitration Center's SIAC Court of Arbitration and the ICC Commission on Arbitration and Alternate Dispute Resolution. His professional appointments include those of Fellow of the Chartered Institute of Arbitrators, London, and their directorship in India, member of the Governing Council of the Indian Law Society, and Vice Chairman for the Society of Construction Law in India. Mr. Pranay Lekhi, our moderator for this evening's conference, is legal advisor, international arbitration, and Allen and Overy. Pranay is a lawyer and legal advisor who has been an advisor to the delegation of the Republic of Maldives for the 63rd session of the UN CITRAL's Working Group 4 on Electronic Commerce and the 41st session of the Working Group 3 on Investor-State Dispute Settlement Reform. He has also been one of the youngest members of the drafting committee of the Law Commission of India and a part of the expert subcommittee analyzing India's 2015 draft model bilateral investment treaty. His research in key areas of international law, international commercial arbitration has been published in leading journals. May I now please invite Mr. Sameer Kochar, Chairman, SKOCH Group, to say a few words and declare panel open.
Namaskar. I'm happy to be among such a sagacious gathering of lawyers with very long-standing years of experience and eminently qualified. I actually have none in law, zero. This conference title is Intersection of Life and Law. So while I leave the law part to you, I'd like to bring a bit of life perspective. I think my field has been socio-economic development of India, more specifically poverty alleviation. Sorry. And today we find that we are vis-a-vis poverty, we are not at a nice place. If you look at what India needs today is, a spatially dispersed, job generative and equitable growth. Is that happening? The economy is today a bit precariously perched. Investments are going down. Rupee is depreciating. Energy prices are going up. The consumer confidence is low. And if you have looked at the CMI data, the most alarming figure of it all is the labor participation rate between 2017 and now has been down 46%. 46% people who could be in a job are not even looking at a job. They've kind of been becoming very fatalistic about it. On the other hand, if you look at financial situations of states, these are precariously perched. So in this scenario, if you look at in context of the last budget, I think government is looking at infrastructure as the savior of the last resort. All the eggs are being put in the infrastructure basket. All infrastructure ministry budgets have been up significantly, and we've got this project called Gati Shakti, which is supposed to speed up things and perhaps answer to the joblessness, incremental capital to output ratio, and areas like that. And in all of that, I find that one great impediment has been a very slow law, legal arbitration, and the enforcement of the arbitration award process. It's an unending exercise. It's like climbing up a slippery pole. Just when you see that you're seeing the light at the end of the tunnel, you find that no, it's actually much more deeper and darker ahead. And we've had cases like Cairn. We've had other cases where arbitrations itself have been lingering on and on for years. And once the award has been done, the implementation of award itself leaves a lot to be desired. So in this scenario, if India really has to become a developed country by 2047, what is it that we need to change? What is it? Yesterday I was reading the Attorney General made a statement that we should set up arbitration cities. But what will you do with arbitration cities unless you fix the arbitration process? And arbitration process is a two-way process. If you do not respect international arbitration awards, who will respect yours? So, a lot needs to be corrected. And I am, as I said, not an expert. The reason I am here and we are discussing this in a SKOCH summit is the profound impact it has on job generation and investments and people wanting to come and build this country. And with that, I would hand over the moderation to Pranay Lekhi, who's been working very hard behind the scenes to help us put together this session. For the first time, we also have a father and son on the same panel who are not coachers. Coacher father and son combination has been for a very long time, but Lekhis have made an appearance, and we look forward to having more of that. Pranay?
Thank you so much, sir. I do echo that sentiment completely. As Rohan started this discussion with that, the enforcement of contracts parameter of ease of doing business in India has remained stagnant over the years. To tackle this limitation, India has definitely taken some measures. These include the Commercial Courts Act of 2015, which incorporates efficiency mechanics from other jurisdictions, such as having case management hearings, as well as requiring pre-institution mediation. More recently, the Department of Justice, in addition to the Gati Shakti portal, has launched the Enforcement of Contracts portal in a series of measures where portals seem to be the new way of managing inefficient regulation and administrative limitations in India. But it still remains to be seen whether these measures are in fact helping the major issue of enforcement of contracts in India. So what this illustrious panel is going to discuss today is essentially two important aspects of ease of doing business. The first remains the enforcement of contracts themselves between counterparties using the civil justice system. And the second, what Mr. Kocher touched upon, is whether and how India can in fact become a global hub for arbitration for disputes. So without further ado, I'll address my first question to Justice Ravindran. Sir, the civil justice system has seen itself as a major issue in terms of enforcement of contracts, and over the years it has come under severe scrutiny for delay and pendency of disputes. Could you please share with us the changes in the judicial approach to obviate these limitations?
Thank you. Judiciary is slow. Judiciary is conservative. Judiciary, some think, is not user-friendly. Now, there may be some truth in it. but none of them is true. Now, as far as the commercial contracts and enforcement thereof, judiciary has been trying to do its bit. Of course, the state has helped by enacting the Commercial Courts Act and amending the Arbitration and Conciliation Act from time to time. And judges, the judiciary have been training the judges in commercial law, Commercial Courts Act, and dispute resolution. And courts have been encouraging litigants, particularly commercial litigants, to have recourse to mediation, conciliation, and lok adalat long before it was made compulsory. Now, of course, under the Commercial Courts Act, pre-institution mediation is compulsory. Even before that, lot of work has been, groundwork was done for referring matters to mediation and lok adalats, and where the resolution can be user-friendly. That was done. And of course, we have been trying to increase the number of judges. We have been trying to improve the infrastructure. We have been trying to, bring in legal awareness. Courts have been trying to do legal awareness about how to resolve their disputes. All these are being done, but are they sufficient? Because the commercial world wants the avoidance of delay. They want a expedited early resolution of the dispute. Second is they want the dispute resolution to be cost effective. Third, of course, they want a fair and well-considered decision or resolution of dispute, which is by mediation. Now, what is happening is you may have any number of laws, but the number of courts are limited. The infrastructure is limited. We started the Commercial Courts Act with a jurisdiction of 1 crore. The cases were limited. A commercial court could handle it. Now, suddenly, the state thought that 1 crore is too much. Let us do it 3 lakhs. Let us reduce it to 3 lakhs. When you reduce from 1 crore to 3 lakh, the number of commercial cases that came before the commercial court grew many times. It became 10 times the number of cases that were earlier there. Consequently, the courts, the commercial courts, are not able to take the load. Now, the simple answer is, why not to increase the number of courts? It is not very easy. We have 40 million cases in India, and out of which only 10 million are civil cases, 30 million are criminal cases. You cannot just shift the courts from criminal law justice delivery system to civil law justice delivery system, because out of the 30 million of criminal cases, 350,000 under trials or loitering or in courts, in jails. Now, how do you give justice to them? You cannot just shift the courts and give it to put it in commercial litigation. Therefore, what the industry and business should do is change their mindset. How do they change their mindset? By concentrating on arbitration and mediation. The simple cases should be mediated. The difficult cases should go to arbitration. That requires a mature thinking, because I find in India that kind of commitment to the cause of mediation and arbitration is not there. The people think, I was talking to some persons who are dealing with commercial court pre-litigation mediation. They said the persons are not just interested in mediation. They, what they do is, because there is a provision that if you are filing a application for interim relief, you need not go for mediation. Therefore, applications are being filed. The commitment towards mediation, commitment towards arbitration will make enforcement of contracts and subsequently enforcement awards very effective. Unless we do it depending on the courts to come to our help at every stage, it may be difficult. let us discuss this in greater detail. Thank you.
Absolutely, sir. Thank you very much for that. Mr. Sinha, just taking this discussion forward, as Justice Ravindran mentioned, that there needs to be a commitment towards arbitration and mediation. India is often seen as a jurisdiction where challenges to enforcement of contracts is actually an easy way out for commercial parties. And a lot of these challenges at times come from regulatory legislation such as the Foreign Exchange Management Act, and the SCRA. We have seen judicial intervention to correct this approach of commercial parties in cases like Vijay Karya, for instance. But how do you believe this commitment can be inculcated in parties as well as regulatory bodies to ensure that this does not happen excessively in India?
Thank you. You rightly mentioned about FEMA. But the trouble with FEMA is that most of the disputes which come to the notice of courts or which arises between parties is because of the several press notes issued under FEMA. It's not the law itself which creates the problem. The problem is that we frequently change the operational guidelines. And number one, it is very difficult for anybody to understand the latest. And second is that how do you deal with the changes? Let me also tell you that the subordinate legislation, I like to come one step before mediation and arbitration, as Justice Ravindran was saying. Let us take one step back, which is how are our laws drafted, and more than law, how are our regulations drafted? And I think part of the problem, a major part of the problem is lying here. We also have a situation where there is often intersection between one set of government agency, intersection between one set of regulator and another set of regulators. And all matters by their very nature are complex. For example, you rightly said about SCRA and FEMA. There are also occasions when the competition law comes into picture. There are also examples where matters of other laws which are important, especially the IBC comes into picture. And here, I like to draw attention of the panel to the recommendations of Justice B.N. Sri Krishna Commission, which headed the Financial Sector Law Reforms Committee. And he has rightly observed there that time has come for us to look at how many types of regulators and what number we are going to have in this country. And secondly, he has talked about the regulation drafting process. He has, for example, the committee, for example, has recommended that we should have in the financial sector only two sets of regulator, one dealing with deposit-taking institutions and the other dealing with the matters like trading of securities. But we have instances where different regulators talk in different voices, and the regulation drafting process is such that often it is done without consultation. For example, the committee had mentioned that in regulatory drafting, there should be as much caution as it is applied in the case of legislative drafting in the parliament. There should be wide consultation. If there are objections raised, those objections should be known to public. But what often happens, and this is the sad part, and this is the root of the problem and creates more difficulties, is that instead of following the regulations, regulators are finding it easy to issue notifications, issue clarifications. And unfortunately, those clarifications and those notifications also have the force of law. I'll give you a recent example, not that I have anything against or for that regulator, just by making a point. Under the LODR, the regulation governing the listing obligations and disclosure regulations, a set of guidelines were issued towards November 2021. My own feeling is that they were very well intentioned. But later on 30th of March this year, the regulator came out with a set of clarifications. And these clarifications also said, for example, that if somebody has started a process of any transaction, but the transaction is also spilling over into the next year, then this requires again 75% shareholders approval. So this, in my view, is a type of legislation having retrospective effect, which should not be resorted to. So and you can imagine what number of litigations will come through in this whole process. So one is that the regulation drafting should be proper. Second and more important is that there should be absolute coordination. I remember when the high-level coordination committee was formed by the finance minister. At that time, there were only 3 members of that committee: the RBI chairman, the RBI governor, the finance secretary, and the SEBI chairman. Now there are 11 or 12 members, and for all different sectors, we have different regulations. So this is creating one problem. Secondly, I would also like to mention that if a regulator is active and takes efforts, for example, to remove the grievances and to settle disputes, it is very easy. And let me give you another example. This example is that under the SCRA, Securities Contract Regulation Act, there are certain powers given to stock exchanges and also to SEBI. Under that, when the number of disputes between brokers and their clients started increasing, SEBI came out with regulations to decide that they will set up arbitrators at 10 places in the country, and those panel was kept ready with the stock exchanges. It was also provided that there will be an appellate mechanism against that. So almost 75 to 80% of disputes started getting sorted out. So by one simple action, taking into mind the main mantra that the disputes have to be resolved, disputes have to be reduced in number, this is how it was handled. I'll stop here, and maybe when you have next round of questions, I'll come. Thank you.
Thank you very much, sir. Mr. Lekhi, Mr. Sinha mentioned about the role that these multiple regulators play and the limitations that are associated with them. The Competition Commission of India has recently been in the news for creating one major hurdle in the enforcement of both arbitral awards as well as contracts. You represented the Competition Commission of India in its proceedings against Facebook. From that perspective, could you tell us what are the structural limitations that India faces in enforcement of contracts?
Well, at the outset, I must say I concur completely with what Mr. Sinha has actually pointed out, because that neatly conceptualizes actually the core problem, which is in some way unsettling the system which is prevalent in India. And the issue here, which is not often addressed, is the principle of legality. And the principle of legality, as all of us here would know, is central to rule of law, and it is aligned to justice. And why I say it's important is because the principle of legality brings in the question of legitimate expectation and introduces an element of fairness in the process, because this question of fairness is important to limit discretion. And it is in discretion that the problem arises. What Mr. Sinha also pointed out, he talked about press notes, he talked about the constant changes that are being made. The press note, constant changes are being made are disarrangement of the system, because the cohesiveness of the system, which has to be manifest in certainty of the fundamental norms as to make it predictable, is affected adversely. To bring in an element of chaos as to ascertain what is to happen. And because business is basically management of risks, if the regulatory mechanism itself multiplies the risks, then the very purpose of the regulatory mechanism is defeated, because the risks get multiplied through the operation of the system, which Mr. Sinha very correctly pointed out. Now, you mentioned the Competition Commission. A very telling point here. As far as the Competition Commission is concerned, in the case which you just referred to, the question was that the provision permitted the Competition Commission to pass such order as it deems fit. Now, when a provision says such order deemed fit, it doesn't in any way entitle the Commission to actually revisit a previous decision, because in revisiting, it unsettles what is in fact a norm which has itself recognized and enforced, to bring about an element of confusion as to what is it that is happening. And the purpose of regulation is to enforce stability, not to create instability. And this confusion creates that particular instability. Now, this particular facet has an aspect also in arbitration. And because we are dealing with arbitration, this is very pertinent because we move to the regulatory part. I have to deal with this question of arbitration. In an Act of 96, 20 and 2022, there's a constant amendment. Amendments are endemic. Now, if amendments are endemic, in fact, the settlement of the law is affected. And what are the amendments about? On core issues. Core issues, whether it is appointment of the arbitrator, whether it is objection to an award, or whether it's dealing with the post-award proceeding on 36, or everything is unsettled. Now, when the amendment is made, the further confusion comes in to what will the amendment apply. So there's litigation. Will it apply to pending proceedings? Will it apply to arbitration proceedings? So there's complete chaos there where application is concerned. Now, once that is settled, the question is, what is the meaning to be given to the particular provision? That is existence of an arbitration dispute, public policy. Now, what is meaning? What is the meaning to be given? That again fuels further dispute. Now, once a dispute is settled, then the government comes in, and the government comes with amendments to either nullify or reinforce. It is completely random. At times it is reinforcing, at other point it is negating this particular amendment. So what happens is that the methodology, the principle of legal certainty is violated and is non-existent altogether, so as to not give any guidance as to what is to happen. And here, coming back to again what Mr. Sinha very correctly pointed out, the multiplicity of the regulatory authority. This is a very, very important point and has to be addressed, apart from the fact that there has to be some kind of cohesion insofar as the dealing is concerned, because this patchwork creates a gridlock of chaos because of the competing authorities exercising the jurisdiction at different points of time on an understanding which is not necessarily unanimous, to create basic disharmony in the system. Now, when there's a question of disharmony in the system, and the disharmony is in the mechanism to resolve, then the resolutions can never take place because the mechanism is in disarray. So what we have to basically see is correct the mechanism and reinforce the principle of legal certainty, which I think is the biggest casualty in India today. Apart from the fact that the basic sentiments, because we have to, it is not simply law. Law cannot address all issues, and this is there's an overreach where law is concerned. The question is more of the underlying sentiment of the people, that the underlying sentiment has to be aligned to this particular principle, so as to give sense and sensibility to the legal provisions and apply them in a manner which makes them efficacious. So it is something which, by reason of its absence, creates an avenue to create disputes and let the disputes fester. Now, if there are disputes and the disputes fester, in that event, as far as the settlement is concerned, the settlement is an illusion. And the settlement is an illusion. The worth of India as a place which will attract investment, which will in fact lure people to its jurisdiction for the purpose of dealing with these matters, is going to be badly affected. So as far as this question is concerned, the basic issue is the principle of legal certainty, legality. Legality is compromised, and it is time we reinforce it.
Absolutely. I think that point is well taken, considering the series of amendments that we've seen come to both the Arbitration Act as well as other legislations that govern commercial disputes. Mr. Goswami, entities such as yourself are the ones who have to face this gridlock of chaos, as Mr. Lekhi mentioned. So in your experience, how do you think managing disputes in the context of long-term contracts in this gridlock of chaos has affected businesses? And what are the key issues that you have experienced in this regard?
Yeah, thank you, Pranay. This is such an esteemed panel. In fact, I myself have been enlightened on so many aspects, and it's so good to listen to all these luminaries. So first of all, thank you for inviting me here. As you said about managing disputes, I mean, from the Vedanta's perspective, Vedanta is such a complex conglomerate, I'll say, because we have PSUs, which were erstwhile PSUs like HZL and Bharat Aluminum Company Limited. And then we have multinationals, and we have, of course, Greenfield and Brownfield, all kind of projects. So there is a complexity of situations everywhere. And from the news also, you understand what kind of difficult situations we have been entangled in various legal disputes and everything. Coming to your question, questions where you are saying about how to manage disputes in long-term contracts. Generally, when it comes to contracts, I think the principles remain fundamental, whether it's short-term or long-term. But from the long-term perspective, there are a few things which are often overlooked. One is sometimes people do not talk about the scope for renegotiation, which is very important. So most of the contracts are written for that particular understanding at that particular time, and those agreements are written without having any scope for renegotiation built within the contract itself. That can be done, which can be very helpful. Second thing, maybe price adjustment mechanism, which is another thing that can be built in the long-term contracts that can also reduce a lot of heartburn or the disputes later on. Similarly, when it comes to the risks, first of all, of course, identifying the risks, and second is creating a risk matrix and a risk division system. So there may be lots of unforeseen risks also. For example, COVID is the biggest example. We had never foreseen that something like COVID will come and put a stop to all the business activities, and because of this, there were so many litigations, so many unforeseen circumstances that were brought in. So of course, I mean, sometimes things are beyond what we can see, but even within the commercial prudence, I think there are lots of things that go missed when we do not look at these things, and we do not build in the anti-litigation mechanism, I'll say, or the resolution mechanism within the contract itself, which is very, very important. That can reduce a lot of arbitration. And we have actually successfully resolved many cases without going into the arbitration system. So that's the first part of it, where you say how to maybe manage or curtail disputes in the long-term contracts. Now coming to a second thing, which is about the issues. So most of the issues have already been addressed by some of the eminent panelists here, that our civil justice system is still complex, is still has not reached that level of maturity where people have immense confidence in this. Even though now, of course, judiciary and the legislature is moving in the right direction, and we are bringing in lots of reformative changes in the laws. We are even curtailing the time period, which is very, very important, because otherwise people used to think that even arbitration had become another kind of litigation. It used to last for years and without having any kind of solution in sight. So that was one problem which has been resolved, but I think still that has not been implemented fully in the letter and spirit. So I still see arbitrations which are going beyond those time periods. Second thing is, arbitration is still costly. It's a very costly affair. It's not a cheaper alternate to the litigation. That is another thing I think which needs to be addressed, which needs to be resolved. So for a small time businessman or an MSME, arbitration still has not been that affordable, I will say. Especially if you see there are lots of retired Supreme Court judges and all those kind of eminent justices who have become very active in the arbitration scene, and so because of which arbitrators, the fees itself has reached, I think, a very high parameter. And then some of the corporates are coming up with senior advocates before the arbitration panel. So the pressure is also on the other side, which may not be that rich corporate or a big corporate, might be a small time MSME or a small time business partner, but he is now compelled to spend a lot for getting a equal kind of lawyer, opposite that senior advocate. So all of these things have added a lot to making the arbitration a costly affair. So that's one thing, I think, cost, then delays. And now, of course, the Indian parties have been allowed, for the foreign seats and something. I think this may be a good step also, but at the same time, this might be troublesome as well, because there are many corporates with their huge power. They might prefer foreign seats, but that again might become unaffordable for the smaller counterparts for these kind of corporates. So these are certain issues, I think, which need to be looked into and addressed. That is, I think, my limited submission into this. Thank you.
Thank you very much, sir. Mr. Karya, Mr. Goswami has detailed the limitations that arbitration as a dispute resolution mechanism in India currently faces. In your considerable experience in managing disputes before various dispute resolution mechanisms, could you tell us whether you believe that arbitration as it stands is an alternative to the civil justice system to avoid enforcement-related issues? Or do you agree with Mr. Goswami that it suffers from similar limitations that makes it inaccessible for a majority of counterparties?
Thanks, Pranay. And I hear Mr. Goswami loud and clear. And this is not the first time that we have heard criticism of arbitration. But I would like to slightly disagree on the concept of arbitration vis-a-vis civil justice system, because we have to compare between the two. And if we have to do that, I would say that arbitration has proved to be a much better alternative as compared to the civil justice system for various reasons. One is the time it takes as compared to arbitration. Of course, we are working towards reducing the time in arbitration with 2015 amendments. We have seen considerable change of mindset in reducing the time. The other is flexibility in terms of the procedure. And I've seen in practice doing both kind of contract enforcement in court and in arbitration. We have seen that the arbitration is much more nimble, efficient in terms of not following the rigid procedural aspect of adjudication. Choice of arbitrator is again a very good example where we have complex commercial disputes. You can go for experts who could be sitting as the arbitrators, and of course you have the wide range of arbitrators who are available to serve on the panel for the commercial dispute, depending on the sector, availability, and the experience required. Award being considered that a decree is a very plus point and a great advantage, because you don't have to reinvent the wheel before the court. Court have to simply enforce the award as if it's a decree of the court. And the grounds for challenge are reducing. Of course, there has been a shift towards the definition of public policy, and with the amendment, we have now curtailed to a great extent the interpretation issues, and the courts are now following the regime of less interference in the arbitration process and trying to intervene only when there is a clear case of patent illegality for domestic awards. And for international commercial arbitration, even though seated in India, we don't have the ground for patent illegality as for ground for setting aside. Of course, we have seen the pro-arbitration approach of the court. We've seen number of decisions which Indian courts have been giving over last decade, which has shown that India is moving towards the arbitration friendly jurisdiction. Cost has been an issue. I see where Mr. Goswami is coming from, and we ourselves are concerned about the cost. But the answer to that is institutional arbitration. And I'm sure Neeti will allude to this concept further, is that unless and until we go for institutional arbitration, and that's where Justice Sri Krishna's committee, where my Lord Justice Ravindran was also there, and we all discussed threadbare as to how to institutionalize arbitration, starting from appointment of an arbitrator, which takes at least 3 to 4 months before the High Court or the Supreme Court, as the case may be. Institutional arbitration can appoint arbitrator within 30 days or even less than that. Availability of emergency arbitrator. You have the cost calculator. So all those advantages of institutional arbitration are there, and I will leave it for Neeti to explain further. The other aspect which we need to look into is the time limit for deciding the challenges against the award and the enforcement of the award. We have now better enforcement mechanism for foreign awards. We changed the definition of court for international commercial arbitration and for foreign awards as the High Court. Earlier, all these matters used to go to district court, and it used to take a lot of time. So that's something we have to now keep in mind. Although there is a 1-year time period provided for deciding challenges to the award, it's not strictly adhered to, and the Supreme Court has now said it is not mandatory but directory timeline. Of course, Justice Ravindran pointed out the stress on the civil justice system. We are adding arbitration on top of that. There is a commercial court, and then there is also the commercial judges are hearing the arbitration matter. The only answer is to segregate. We have to keep the arbitration matters separate. We have to have a specialist courts dealing with only the arbitration matters. And especially for foreign awards enforcement, we need to have a fast track process, because we are getting a lot of bad reputation in terms of not being able to enforce the foreign awards in India. Although the successful party has been getting an award, but they are not getting the fruits of the award. The last thing I would like to mention is about the costs for all these proceedings. For unsuccessful challenge to the award or unsuccessful resistance to the enforcement of an award, there has to be an actual cost. The jurisdiction like Singapore and UK, we have to give the costs in advance for the other side to show your bona fide that you really believe in challenging the award or resisting the enforcement. And that is something we need to adopt from other jurisdictions to avoid frivolous and time-consuming challenge procedure. All those things will definitely make arbitration more conducive for contract enforcements, and we all have to work together. Of course, there is a lot of shift in the mindset. We are now having specialist independent arbitrators. We are creating arbitration bars, so we don't have to rely upon senior counsels who are regularly appearing in the court, and they give up their court matters to come to arbitration, and they charge 10 times than what they normally charge. So all those things we need to work, and we are working towards it. But it's just a question of time by which we would be making our arbitration regime at par with other jurisdictions. Thank you.
Thank you very much, Mr. Karya. I think it's appropriate to take the point of institutional arbitration further to Ms. Sachdeva. Ms. Sachdeva, in Indian contracts, we often see ad hoc arbitrations more generally, and institutional arbitrations are a more recent phenomena. Mr. Karya also mentioned the aspect of costs, but if international experience is anything to go by, then institutional arbitration can also often lead to a high amount of costs, especially in the context of SIAC and LCIA. How do you think and how do you view the role of arbitration institutions, especially such as MCIA, as an emerging option for dispute resolution in India in the context of enforcement of contracts?
Thank you, Pranay, and thank you for inviting me. I think it's a very relevant topic, and I thank you, Pranay, for putting a question of that sort, which helps me to talk about institutional arbitration, something that I have been championing the cause now for almost 15 years in India. I totally agree with you. You know, when we talk about, and all the eminent speakers have spoken before me, and I've spoken about all the problems associated with arbitration, I think we need to make a distinction. When we talk about arbitration in India, we're talking about ad hoc arbitration, and the way that ad hoc arbitration has worked for that long. I do not say for once that institutional arbitration is a panacea to all the problems. But if international experience is anything for us to learn, then clearly we can learn from it that institutional arbitration is probably the only way that you can bring in efficiency and effectiveness in the whole dispute resolution process. You know, Mr. Goswami was talking about delays and costs, which I'll answer. Mr. Upendra talked about drafting of arbitration clauses as well. If you look at an institutional arbitration, and if you simply go onto the website of any leading arbitral institution, you have a standardized arbitration clause itself. All that a party needs to do is copy and paste in there. And a lot of your problems are resolved in terms of not litigating or not arguing about the whole arbitration clause itself, right? An arbitration clause is an effective door to an entry to a dispute resolution. Let's come to the cost as well. They just mentioned about it that, the cost may still remain a kind of a deterrent for use of arbitration, despite all the advantages that he listed down. There was a study which was done by ICC long back, almost about 10 years back, and they did it is a published study actually, and they did a study on the techniques and the cost of arbitration. And when the costs of arbitration were divided into, the three costs, which is the institution's cost, the cost of the arbitrator, and the counsel fees. And they reported it to say that it's only about the 2% of a cost of an arbitration is what an institution cost is. 18% of the cost is what is the cost of an arbitrator. And the rest 70% is the cost of a counsel, right? So when we talk about regulating arbitrator fee, regulating whether the institutions are charging a lot, I think it's really a myth that institutional arbitration is expensive. And why? I mean, if you look at the cost comparison, the beginning itself, if you are, let's compare, apples to apples. If you are just appointing an arbitrator, we all are well aware if it's an ad hoc arbitration, it's very difficult for parties to agree onto a name of an arbitrator. And you see yourself in a court. A court means that you will have a court fees paid, you will in all likelihood have lawyers, you'll be hiring, there'll be an additional cost and a time involved as well. I think Tejas was being very conservative to say that it takes about 3 to 4 months. We all know it can take about a year to get an arbitrator appointed itself, and that's a cost involved. Whereas if you are in any institution, those costs, there are no distinct costs for that. It is very much absorbed within the institution's cost itself. Now, when you're running an arbitration as well, we all know that in an ad hoc arbitration, no party wants to negotiate their fees with an arbitrator, right? That's the last thing that you want to do. But if you're an institutional arbitration, except for LCIA, let's keep that apart, but whether you're an MCIA, SIAC, ICC, we have an ad valorem system which gives the parties a complete indication of what the cost of an arbitration is going to be in terms of an arbitrator. What is the institution which is going to, what they are going to be charging you as well. So the parties are well aware at the beginning of a process itself as to what good money they're putting behind the bad money. And if you compare, I would say there's some of the very good Indian institutions as well. It's a phenomena which is picking up now. We may have been a little delayed in comparison to the international community, but I think we are right there with MCIA, NPAC. There's a center in the Hyderabad now. There are many other centers within India. And if you compare their cost with any of the foreign arbitral institutions, it's considerably lower. Right. So if you look at, just to give an example of MCIA, because I represent that institution here, is that if you look at the fee of the arbitrator, it's not very different from what SIAC's or ICC fee may be, but maybe a distinguishing factor of about 10 to 15%. But if you look at the administrative fee, which an institution charges, the difference in amount with an ICC to an MCIA fees is almost about 60 to 70%. And it's a huge amount when you have a larger arbitrations involved. So in terms of cost, I think it's a myth that institutional arbitrations are expensive. Yes, arbitrations have been expensive in India, but it'd be right to say that it's ad hoc arbitrations which have been expensive because there's no set of rules to regulate it, right? You're not able to negotiate the fees with an arbitrator. It's mostly on the per session, per hearing basis. So there is no third party who's regulating that as well. Let's come on to delay as well. I think with institutions, that's another thing, because institutions are very careful that when they appoint the arbitrators, they take a disclosure not only about their conflicts with the term of the parties or the councils or the subject matter, but a detailed disclosure is also obtained from the arbitrator about their availability of time. And if they do not have an availability of the time for the next 6 months or 8 months, howsoever good an arbitrator they may be, is just as no use to the parties. And the institution will not appoint them. So appointment of an arbitrator, if you can make sure at the time of an appointment itself that you have the right arbitrator who understands the subject, who has the availability of time, then you considerably reduce the time involved in an arbitration. And the last point before I conclude is that if you look at the scrutiny of an award provision, which is in the institution rules, some of the institution rules like MCIA as well, I think it is a very good safety net. An award is scrutinized not on the merits, but on the soft parts of it to make sure that there will be no procedural irregularities in that sense. Everything has been recorded properly in the award, that tomorrow that award is not challenged in the court on frivolous grounds. And also when an institutional award, and an award from an institution is before a court, we have, at least in our experience, seen that the court has a larger confidence in the award itself. So the chances of it being interfered with also gets reduced. So I think that maybe not completely a panacea to all the problems, but going forward for effective resolution of commercial disputes, institutional arbitration is just the way forward.
Thank you very much for that. And I think that's an appropriate segue into the second half of the discussion that we were aiming to have, which is how do we make India an arbitration-friendly jurisdiction? And of course, that question cannot be answered without having addressed the issue of institutionalization of arbitration. Justice Ravindran, Mr. Lekhi was speaking about the legality as an aspect of rule of law that's essential to making there being some degree of confidence in the regulatory structure of India. If we take the parable of Rex from Fuller, the number of amendments that have been made to the Arbitration Act only in the past 6 or 7 years has been almost too many for there to be any consistency between laws, and these have in fact been disregarding previous changes. For instance, the 2019 amendment annulled a lot of what the 2015 amendment did. Mr. Karia also mentioned about the segregation of commercial disputes from other disputes, especially in the context of enforcement of foreign awards. How do you view, on the one end, excessive tribunalization that segregates disputes into definitive silos before courts, when you've already mentioned the limitations that the Commercial Court Act is facing? And what, in a related sense, in your opinion, would be an effective legal mechanism to support the policy intentions of making India an arbitration-friendly jurisdiction? Apologies, sir, I think you're muted.
Pranay, something was said about the amendments to Arbitration and Conciliation Act. See, we had a 1940 Act, then we replaced it by the UNCITRAL model without adopting it to the Indian conditions. That's what happened. We just, imported it. And after working it for 10 years or 15 years, there was a lot of complaints from the industry, from the users of the Act, saying that, look here, this is not working, this is unreasonable, this should be corrected. Well, because there was a big hue and cry about the various terms of the various provisions of the Act, the Law Commission report was taken and the first amendment was made. Of course, the 2015 amendment. Now, 2015 amendment also gave rise to some problems. Therefore, a committee was constituted. I was there along with Justice Sri Krishna, and I think Mr. Karia was also there. And what happened? We suggested certain amendment to set right the deficiencies that were noticed in the working of the 2015 amendment. Now, that amendment came in, but you will be surprised. It is not as if there has been a change. The main provisions are not given effect to, in regard to institutions appointing arbitrators instead of the court appointing arbitrators, constitution of the arbitration council, and various other matters, encouraging institutional arbitration. All this is in cold storage, even though the amendment was made. Therefore, it is not as if that there has been a very, very monumental change. There were changes which were necessary. They have been made, and when they found that there were corrections were required, corrections have been made. I think with these corrections, if the amendments are given effect, there is hope that the Arbitration and Conciliation Act may be more workable. This is the first thing I wanted to say. The second thing I want to say is about how do we make the India a great attractive destination. Well, it is very easy to put the question. Now, there are 4 complaints about Indian arbitration. The first is delay, second is cost, third is lack of professionalism among the arbitrators. Number 4, too much interference or intervention by the courts. Now, things have been moving. You see, in regard to delay, yes, now timelines have been prescribed. Now, regarding cost, an effort is made, conscious effort is made to shift from ad hoc arbitration to institutional arbitration, where there will be, some kind of ceiling in regard to fees, and the parties will know where how much they are likely to spend. Now, as far as intervention of courts is concerned, now several decisions of Supreme Court have come which discourage, intervention, unnecessary intervention. Therefore, we are moving in the right direction. But then, why is it not that India is a favorite destination, or why is it that arbitration is not as successful as it should be? Now, first thing I would like to point out is, you see, in Indian arbitrations, PSUs and government is a major litigant, which is not so in various foreign jurisdictions. the Indian government and its instrumentalities are big litigants in India in arbitrations. Now, what is the mode of contract they are using? You see, the contracts say, most of the PSU contracts you will find says, when there is delay on the part of the PSU, when there is delay on that is the employer, when there is breach on the part of the employer, the contractor will not be entitled to any damages. You will be only entitled to extension of time. You will not be entitled to revision in prices. Mr. Goswami mentioned about the need for a price adjustment in a long period contract. No, these provisions are not there. This is one reason why there is too many arbitrations in India, taking too much time, because the contractors who are actually the litigants who come to the arbitration are fighting with their hands tied because of the contractual provisions. This is one thing. Second thing is the Indian mindset. No, Indian mindset of lawyers and Indian mindset of the parties. It is the industry that should change its mindset. What is happening, I have noticed in all arbitrations, this is in India particularly because our your success and failure is not linked to the cost. If you have a claim for, let us say, 100 crores, the tendency of an Indian party is there is no court fee to be paid. Instead of 100 crores, I will make 500 crores. This is what is happening. You will find in most of the contracts, if it is for price or if it is for services rendered, if the cost is 100 crores, you will find damages will be 1,000 crores. And for loss of reputation, would you believe it? Loss of reputation in a breach of contract matter, 100 crores. Now, what will happen? You have a claim for 100 crores. You make the claim for 1,000 crores. And because it has, instead of a 100 crore arbitration, it has become a 1,000 crore arbitration. You don't want a normal, let us say, an advocate arbitrator. You don't want, let us say, a retired district judge who is an arbitrator. You don't want a high court judge as an arbitrator. You want a Supreme Court judge, because you have made your 100 crore claim into a 1,000 crore claim. Because it is 1,000 crore, and because you want a Supreme Court judge as a retired Supreme Court judge as an arbitrator, the cost goes up. Because the lawyers also have a vested interest in the sense, if they conduct an arbitration where the arbitration amount is high, where the fee is high, arbitrator's fee is high, he can also charge more. Niti was mentioning about, out of 100 rupees, if 100 rupees is the arbitration cost, 75 rupees is the lawyer's fee. 20 rupees is the 17 to 20 rupees is the arbitrator's fee, and 2% of the institution fee. We should get rid of in foreign jurisdiction, this do not happen, because if you have a claim for 100 crores, you make a claim for 100 crores. Because they know if they make a claim for 1,000 crores, and if they lose in regard to the 900 crores, they will have to pay more cost to the other side than for the cost they will be getting for succeeding for 100 crores. Our mindset should change. Now, this is the mindset of the litigant. What about the lawyers? See, in Delhi, it is normal. All the lawyers, with great respect to the senior counsel also who are there, they want arbitration at 4:30 after the High Court. They want arbitration on Saturdays only, and sometimes Sundays also. They are not willing to conduct it in continuously for 1 week or 10 days and finish the matter. I have seen the same senior counsel appearing before me in arbitrations in SIAC, coming and sitting in Singapore for 1 week and completing the arbitration. But the same arbitrator, same lawyer, conducted in India, it goes on for 20 hearings, 30 hearings, 1 hearing today, 1 hearing tomorrow, 1 hearing thereafter, 1 year at 4:30, 1 at 11 o'clock. You see, this is lack of professionalism. We do not have a committed bar, a professional bar. As rightly said by Mr. Karya, it is slowly developing. We are not saying that all is negative. Now time is being controlled. Now a professional arbitration bar is slowly evolving. People have now coming forward and conducting cases, but it is taking time. It is taking time. Our arbitrators are no less than foreign arbitrators. Our lawyers are no less than foreign lawyers. But the culture of taking it easy, which has been part of our culture, that is coming in the way of efficient and effective arbitration. Once we become more professional, I am referring to lawyers, I am referring to arbitrators, and if courts do not interfere much, I will tell you the problem. You fix the time as 12 months for making an award. Let us say it is made in 12 months. And in most of the states, except in Delhi and Mumbai, in most of the states, the challenge under 34 is the city civil court. In city civil court, there is no admission system. Automatically, the challenge is registered like a suit and matter takes 5 years. Then it goes to Supreme High Court, another 5 years. Then it goes to Supreme Court, another 5 years. What is the use of regulating and ensuring that the arbitration is completed in 12 months, but it takes 15 years in court? There should be a corresponding change by committed commercial courts for arbitration who will complete the matters in time. This is required. What I am trying to say is, it is not just we say we should make India attractive destination. We should all work for it. The lawyers should work for it. The judges should work for it. The arbitrators should work for it. It is not just happening. And another thing, let me tell you about the, again, Indian mindset. You will find a party enters into a solemn agreement with arbitration agreement. Now he comes to arbitration. First, he challenges the arbitration agreement. Then he challenges the arbitrability of the disputes. Then he challenges the jurisdiction of the arbitration. Out of 12 months that is fixed for deciding these matters, it takes 6 months. Why is this mindset? You have entered into an agreement. You have provided for arbitration. You better get along with the arbitration and finish the dispute. Unless we get that mindset, unless we have a commitment to the cause of arbitration and dispute resolution in a professional manner, whatever are our efforts to popularize arbitration, we may not be able to succeed. Why I am saying it? I am an ad hoc arbitrator. I know what is happening in ad hoc arbitrations. I am a trustee of a arbitral institution. I know what is happening in the institution side. Unless the change comes from lawyers, unless the change comes from the industry itself, whatever may be the effort of the courts, whatever may be the effort of the state in making laws, and whatever may be the effort of the arbitrators to quicken the justice delivery, there may not be success. Therefore, I appeal to the industry to be more professional and ensure when you are entering into the agreement, you do it properly. You see, again, I think it was Mr. Goswami who was mentioning, see, there is no provision for increase. There is no provision for damages, no provision for interest, and you enter into an agreement and then have litigation. The government also should, you see, the state also should be practical and appoint a committee to bring the contract form, the standard forms of contract, engineering contract, construction contract, or all kinds of contract in consonance with international standards. That is one way of reducing litigation, quickening the process. Thank you.
Thank you, sir. I think there's a lot to unpack in the points that you've made. So it's only appropriate that we take one of the points of mindset to a lawyer to address. Mr. Karia, one of the key changes that was made by the 2021 amendment is the removal of the court's discretion in deciding a stay of enforcement. Given Justice Ravindran's point on how easy it is to resist the enforcement of arbitral awards, both foreign and domestic, adding additional grounds in Section 36 may be viewed as a step back and not a step forward. What is your view on the legislative developments in this context?
Certainly, thank you, Pranay. And I know that we have come a long way, and 2015 and 2019 amendments were quite progressive. But 2021 amendments, maybe whatever reason it was brought in, brings in a kind of an apprehension that what we achieved, maybe we took 2 steps back, and tried to bring in an additional ground for granting unconditional stay. And just to explain, in 2015, we got rid of automatic stay because the moment you challenge the award, we could not enforce the award till such time the challenge is over. And we brought in the specific provision under 36 for asking for specific stay of the enforcement by depositing the amount. Now, that was the condition which was imposed by way of the amendment. The 2021 amendment took away that power of court to impose condition in the case of prima facie, case of fraud and corruption, not only in making the award, but also in the underlying contract. And these are some problematic issues because it was made applicable retrospective. That means the pending arbitrations and the applications before the court also, this amendment was made applicable. And also that prima facie, when you have not raised this issue before the arbitral tribunal, can you raise it before the enforcing court or a setting aside court was an issue. Secondly, what is the meaning of fraud and corruption? Because again, those are broadly wider terms. Even in the section 34, there was already a ground for making an award through corruption or fraud was already there. This goes beyond because it also goes to the underlying contract, which was not the intent of section 34. I'm sure there were certain reasons why this amendment was brought in, but this may open a floodgate. Fortunately, in last 2 or 3 years, we have not seen that kind of those many cases. Of course, in 1 or 2 cases of mine, the as party wanted to reopen this whole issue of saying that whatever amount I have deposited, you refund it back to me because now there was a fraud. We pointed out that this fraud thing is coming only after the amendment for the first time. So you showed the intention is clear. And fortunately, the court appreciated our argument and said nothing doing. You can't just take the ground of fraud by way of an afterthought. But these are the problems with this kind of amendments which were brought in without thinking it through. If you see, 2015 amendment was based on the Law Commission report. 2019 amendment was based on Justice Shri Krishna and Justice Ravindran's committee's report. And 2021 was brought in for one particular case, which I would not like to name it. So therefore, this is the thing we should avoid. And this is for the courts now not to fall in that trap. And the fraud and corruption should be interpreted in a very, very narrow sense and only in exceptional cases. This amendment should be brought in, and otherwise the general rule of making the parties deposit the entire amount, award amount, or the part thereof should be followed so that we put a check and balance on frivolous challenges to the award. Thank you.
Thank you, sir. Just taking the point on amendments forward, Mr. Sinha, 2 questions for you. The first, Justice Ravindran mentioned that a lot of the amendments have come at appropriate times to address standing issues that the industry and various stakeholders have faced. You mentioned the point of regulators coming up with excessive circulars. The first question is, how do you view the constant changes to the Arbitration Act within a period of 5, 6, and then 7 years from an industry standpoint? And then secondly, the question that we have is in relation to the definition of public policy of India. In not so recent judgment, the Supreme Court had said that statutes like FEMA, a violation of them would not constitute a violation of public policy of India. How do you view statutes that regulate financial transactions in the context of Indian public policy is the second question. So I believe you're on mute.
Thank you. Coming to your first question, instead of evaluating the amendments already made or criticizing them, let me suggest 2 more amendments. You may be amused to hear this, but let me say that. Number 1, if an award has been given, how do you enforce that award? What is the mechanism for execution of the award? You go back to the civil courts again? How do you ensure that? We had this problem in SEBI. We used to pass orders against many defaulters. We used to award penalties and all that. But we used to go to the civil courts, and it used to take almost a decade. So my recommendation is that we should give the power of recovery officer, we should provide that there is a recovery officer in different jurisdiction, in different places, who can have the requisite power to enforce the awards. Because if the award is against a private party, he will explore all the other options. And what I am saying is that the Income Tax Act, for example, have this. If they impose a penalty, they don't go to a civil court. In SEBI, we got that power, and that has helped a lot. So first point is about having the mechanism for effective execution of the award. The second point I would like to highlight here for consideration of everybody here is that let us recognize the role of data agencies. Unfortunately, this aspect has not been discussed widely in this country so far. And just to give you a little bit of perspective, in mid-90s, when the Depositories Act was passed in this country, it became clear that if your name is registered with a SEBI-regulated depository, your ownership of a particular share or a particular security is established. The transfer of security from A to B is established. And that became the main source how the disputes were reduced and how the volume went up. Fortunately, now we have an example under the IBC. Under the IBC, we have a concept called information utility, IU. And the IUs have now, the parties have perforce to give all the data to the IU. And being a member of the Insolvency Law Committee, I can share with you that we have made a recommendation to the government that right now what happens under IBC is that the very fact that with what evidence, at what stage you admit that there is a default or there is an admission of debt. So if the data is provided in the IU, then why not have the IU data, the information utility data, as the full proof of admission of default? That will help the system by almost 6 months to a year, because right now the delay takes by several months because of this delay. I'll also like to say that under various financial laws, now utilities have been provided, data companies have been provided. For example, we have account aggregators under RBI. We have other credit information bureau under RBI. So what I'm trying to say that the larger system should take note of this electronic development, that lot of useful data by agencies, which are vetted agencies, which are regulated by some regulator, are available. So instead of relying on preliminary evidence under the Evidence Act, there should be legal provision that this can be admitted, and that can help. So these are the 2 points about amendments. On the question of public policy or what constitutes public policy, my personal feeling is that if it is a question of fraud, if it is a question of corruption, these two circumstances or situations should only be counted. Otherwise, courts should not be allowed to interfere in this matter. Courts should not encourage interference, and the arbitration awards should be allowed to be carried through. Thank you.
Thank you, sir. I'll take the points that you've made to Mr. Goswami. Mr. Goswami, the first question, is an Indian conglomerate or an Indian corporate entity ready for further amendments to the arbitration law and the regulatory regime generally? And in that context, the second question is, how do you view the regulatory landscape of arbitration in India? And given that the Supreme Court has now allowed for foreign-seated arbitrations for Indian entities, is that something that corporations such as yourself are considering, or do you think that it'll still take time for entities to take that up?
Thank you, Pranay. I think about the arbitration landscape in India, Tejas has already, in very detailed manner, he has already explained what are the changes which have been made to the entire landscape. Other senior eminent panelists have also very clearly and suggested ways how this can further be improved. I mean, of course, so far the changes in the arbitration landscape have been made very in a very, I'll say, progressive and encouraging manner. So you see, there have been very landmark judgments by the Supreme Court wherein the intervention by the court is being discouraged day by day. Similarly, Mr. Karya mentioned about that earlier. It was, if you went under Section 34, there was an automatic stay on the award on the arbitration. But now Section 36 has done away with that. So there is no automatic stay as such. You have to separately go for that. There are lots of things. Similarly, for the international commercial arbitration, earlier there was a lot of I'll say there was no clarity in the market as such how the international commercial arbitration is going to work in India. But now that clarity has also been brought in through the amendments and also through Supreme Court judgments. Similarly, about the seat and venue, this also created a lot of confusion. So lots of confusions have been already cleared by the judiciary as well as also by the legislative amendments, which has been very, very, I'll say, encouraging for creating a better arbitration atmosphere. But as I previously said, and I think some of the panelists agreed also with the things that we need to make a shift change in the arbitration process. So what's happening, it is still the players in the arbitration field are still the same players who are running the litigation field, litigation arena. So maybe if we shift towards the institutional arbitration, that might bring a fresh lease of life to the arbitration process. And most of the people, in fact, I mean, very senior people in the organization itself, they are generally not in favor of arbitration for these reasons. They generally say, let's do away with the arbitration clause in our agreements. We are not getting anything. Almost 100% of our arbitrations are ending up in the courts again. So that's not a very encouraging scenario. So even though the legislature has been amended, wherein, fast track arbitration has come up, they have very much curtailed the grounds on which the arbitration award can be challenged, and mostly no court will go into the facts or something if an award has already been provided with all the reasons. So that's a very good change, I think, on the legislative part, and similarly on the court's part. But again, I think institutional arbitration needs to be encouraged and to be brought in the mainstay that will make it accessible to, I think, most of the business fraternity. As of now, even the business fraternity is not very, I'll say, encouraged or very much motivated to go or to try arbitration in all the cases. So they will either go for one-on-one settlement, and if that doesn't work, they will probably find out a way to go to the court directly, because they have that mindset that ultimately it has to end in the court itself. So that is somewhere we have to shift that, that mindset. It's already shifting. Legislature is doing its work. Supreme Court has given a lots of landmark judgments which have also been in the right direction. But I think institutional arbitration again needs to be encouraged, and they need to provide more awareness and more education to the industry as such and to the public at large. And experts should be involved more in arbitration. We are still seeing, as I said, the players are same as we see in the litigation on the courts. So we are still having the same judges, same senior advocates, everything. So ultimately, that arbitration process takes up the essence or character of normal civil dispute or a litigation dispute. So we have to make a shift from that side also, and we have to depend more on experts for deciding maybe an EPC contracts or a technical contracts. Or there we can see that how we can move this from a typical judiciary mindset or the typical civil court mindset to a professional arbitration mindset, where we have experts who understand that thing, and maybe they can make it quicker and it might be more cost effective as well. So
absolutely, sir. I think those points are very well taken. Ms. Sachdeva, I think it'll be music to your ears to see the uptake of institutional arbitration amongst this panel and more generally in India as well. We were speaking of appropriating best practices from different jurisdictions for the promotion of institutional arbitration. So the related questions I have is with the practice of arbitration. The panel mentioned having a specialized bar for arbitration. So how do you view that? And a slightly personally motivated question, how do you view the role of foreign law firms coming into India for the purpose of arbitration as well?
Thanks, Pranay. You're absolutely right. It's music to hear to see the uptake of institutional arbitration. I'm glad that, as they say, that every single person adding on the journey makes the journey more beautiful. So I'm happy that, everybody at least here agrees to institutional arbitration. In terms of arbitration bar, I think that is the next step that India will have to take to create that arbitration bar. We know of organization like the IAF, which is the Indian Arbitration Forum, which promotes to have people practicing purely in the arbitration side. I think as Tejas mentioned, and I think even Rajiv was saying, arbitration can no longer be an evening affair. It can no longer be a weekend affair. And if you need to have those specialized lawyers doing arbitration, then you need to have a bar where they're ready to give up their court litigation to do arbitration. I think the skill sets required are also very different. I mean, what you practice in an appellate court, in a Supreme Court, or what you practice in a high court in many of the jurisdictions is very different from the trial work that you ought to be doing in an arbitration. So there are definitely different skill sets required there as well. I think it's a slow progress. We know of people who have given up their court practice, successful people who have given up their court practice to move into the field of arbitration and are doing absolutely wonderful. We know of courts who are appointing younger practitioners as arbitrators, and these younger in the arbitration world, if you're 45 plus and 50, still you're young in arbitration. So yes, I'm using that word in that comparison. Younger arbitrators are accepting arbitration and moving towards looking at that as a career opportunity. In fact, I was reading this post by Irvinder Bakshi. She was a CIR president, and she was talking about how, as a woman also, arbitration and a dedicated practice in arbitration can be so helpful, where a lot of time we know that talented women have to give up their career options because of the family way and their commitments at home, and they're not able to match the diaries of a court and the difficult litigation practice that we have in our country. So I think arbitration comes as a very useful tool for even women to manage their diaries, to give that importance both to their work and their family. It's only time that we will, I'm sure, we've started to work on it, and probably 5 years down the line, 7 years down the line, we will see more practitioners who are purely doing arbitration practice and adding on to it. Coming to your second point, I think that the foreign lawyers are still practicing in India. We do see a lot of foreign lawyers, especially in the field of arbitration, that you have a lot of foreign lawyers who co-counsel with Indian lawyers. We do see a lot of foreign arbitrators, when I say foreign in terms of non-Indian arbitrators, who are appointed as arbitrators in the Indian-related matters as well. There's a growing practice there as well. Clearly, Pranay, as a good lawyer myself, I should say these are my personal views and not of the institution. I think, and MCIA has always believed in it, that a good competition only helps bring up the subject, right? So if tomorrow we have foreign law firms coming in and there is a good international best practices being incorporated, it is a good, healthy competition out there, I think it's going to benefit the legal industry per se. It's time that we should start thinking about it in a more tangible way. I mean, taking example from Singapore, our nearest jurisdiction possible, doing great in arbitration. For the longest time possible, they did not have foreign lawyers who could practice in the courts. But they slowly started to open up to say, maybe the transaction work could still be done by them. And then they said that you could, if it's a non-Singapore law point to be argued in a court, you could have a non-Singaporean lawyer doing that. But to advise on a Singapore law, you still needed somebody from Singapore. And I think India should also now look at opening it in phases to say that if it's an Indian law issue involved, you still have an Indian lawyer. But if, let's say, it's an English law issue involved, or any other laws issue is involved, why can't we have foreign lawyers doing that work, right? When they're still being co-counsel. I think the time has come that, and the two things can definitely work together, in parallel, to make sure that we have a robust arbitration bar. And I think it's the responsibility of the newer generation of arbitration to take that mantle forward. And I think definitely time has come for us to welcome the foreign law firms with open arms and bring in that competition, a healthy competition, to raise the bar for ourselves. Absolutely endorse that idea.
Thank you so much, Mr. Chdeva. I, of course, in wholly my personal opinion, could not agree more. Mr. Lekhi, just to put this entire discussion into context, we've heard the good, bad, and ugly of the arbitration landscape in India, as well as the issues of commercial enforcement that India is facing. There have been opinions to suggest that India is on the right track to be an arbitration and enforcement friendly jurisdiction. But do you think that India is indeed on the right track in the first instance? And if not, to conclude this discussion, could you please tell us what suggestions you have to ensure that it becomes one?
Well, I feel we definitely are on the path, in the right track, to become arbitration friendly, no question about that. However, there are certain issues which I would yet like to address. Amongst them, of course, Justice Savendran has dealt with the aspect of the lawyers and the business. But what I want to bring to focus is not just the lawyers and the business, the role of the state. And I think the role of the state, both in the context of formulation and change of law, is extremely material for the purposes of having a stable arbitration jurisdiction, which has to be addressed because flux is not good. And flux provides an excuse to challenge. Excuse to challenge in the multiple fora of litigation adds to both expense as also time, and that frustrates the procedure because it's ancillary to arbitration proceedings. So the very fact that we've been making changes, even the changes are warranted, is in fact something which we should avoid, because if the changes have to be made, the changes should be made in one go rather than incrementally over a period of time, which should not actually happen. This is one issue which we have to address. That said, very pertinent to the question was the culture. And here I want to bring this particular issue. This is absolutely pertinent, and Justice Abhindan actually dealt with it, that our preferences for choices, both procedural and substantive, are exogenously produced by our existing legal tradition. Now, because that is so, it constrains our choices. So norms have to be manufactured. Norms have to be made. And norms have to be made to an interactive exercise. And if norms have to be made to an interactive exercise, there has to be cross-national integration. And insofar as movement away from the autonomy of the system, that we should not be a closed system. And here what Niti said is very pertinent. And both aspects I agree, that as far as the question of engagement with other jurisdictions through the respective trained professionals is something India should not be averse to, because that is something work to the advantage of India, as it has happened in the context of Singapore. That said, because much focus, and very correctly, is placed on institutional arbitration, what is very pertinent is that insofar as the amendments is made, if once we bring in the concept of institutional arbitration, as has been done in the instant case, then you have to complete the process. Now, that process cannot be left in limbo. Now, this process is being left in limbo, again, by whom? By the state machinery, by those in charge. Now, if you introduce a concept and it's worthwhile, you have to complete the process. When we're not completing the process, it's going to be a problem in any case, insofar as that aspect is concerned. But that said, what is important is that the grading and accreditation is extremely important, and that should be professionally done. And as far as that question is concerned, that there should be least possible governmental interference. Number two, insofar as autonomy is concerned, autonomy should be respected. That will go both to the arbitrator as also to the lawyer. And of course, as Niti correctly said, if it's a foreign law, it can assist the lawyer, but the question is don't exclude the lawyer. Number three, what everyone agree, that has to be reduced interference insofar as the particular process is concerned, and expeditious implementation. There's a convergence so that is concerned. Insofar as the practice is concerned, there's general unanimity across jurisdiction that has actually to be so. And fourthly, what is important is perception. Insofar as the question is the perception of arbitration being effective. And because perception of arbitration being effective necessarily means the infrastructure is actually in place, both the social and the physical infrastructure. Social infrastructure will go to the understanding. Physical infrastructure would go to the method by which it has to be actually brought about. So the standard template has to be produced. In fact, putting into crucible all the points which have been actually raised. But the core issue would yet remain, because there's general agreement as to the efficacy as an alternative dispute mechanism. As far as the attraction of India for this particular purpose, it entail leveraging our grasp over the language, which is very significant, our understanding of the common law, because that is in fact across all jurisdictions, that is so, with of course our interaction with other jurisdictions, without any apprehension as to the consequences which will actually follow, through a system which is stable and secure, applying norms which are settled. And if that is so, I personally feel that as far as all attributes for a successful arbitration jurisdiction is concerned, India has it, and India can actually exploit it.
Thank you so much, Ms. Lekhi. That has made my job to conclude this panel a lot easier, because that has very appropriately summarized the views that are the main takeaways from this panel. We have completely run out of time. So despite my penchant to extend this fascinating discussion, I think we'll call it a quietus for now. My thanks to all the eminent panelists for taking out time and discussing this very pertinent issue. And we hope that India and the state, as Mr. Lekhi mentioned, is listening, and we can take this forward and make India into an arbitration-friendly jurisdiction and a jurisdiction that's friendly to the enforcement of contracts. Thank you very much to everyone.
Thank you. Thank you, Pranay.
Thank you, Pranay. And thank you, everyone. Thank you so much.
You.
It was wonderful.
Thank you.